want to talk to David Davis. He joins me, former Conservative Party chairman, former Shadow Home Secretary. Good afternoon to you.
Afternoon.
I heard Lucy Letby's new legal representative, or one of that legal team, talking on LBC this morning, saying that while there is no new evidence, there is new interpretation of evidence that was assessed in the trial. Is that sufficient for a proper review, a formal review of these convictions?
Well, I think the first test is where does justice lie? Is this woman guilty or not? And that was the test I applied when I first looked at it. And I spent 3 months trawling through the evidence to try and find a slam dunk, if you like, to prove that she's guilty of one murder. And I couldn't find one, not out of the 15 or so that were in play. Now, with a case as big as this, which went on, it's the longest lasting criminal case, I think, in modern times, 10 months. There's huge amounts of data, huge amounts of information that could be interpreted in all sorts of different ways, and has been. I mean, if you just look at the arguments between the experts in the last few months, the idea that this young woman is guilty beyond reasonable doubt has become laughable. I mean, the leading experts in statistics, the leading experts in forensics, the leading neonatal experts, past presidents of the Royal College of Paediatric and Child Healthcare, all these people have looked at the data and said, this is not proven. In fact, just the opposite. There are other reasons for the deaths of these very sick, premature babies. They're neonatal, as you say. They're premature babies.
Well, there was that very notable press conference, wasn't there, just a few months ago, of global leaders in neonatology, I think they call it, don't they? That those who had written the books, the papers, the peer-reviewed papers on the kinds of clinical reasons that might have contributed to the deaths of those babies, as opposed to outside intervention that was malign in some way. All of that taken, what you have said, what they said, is the strict criterion that new evidence needs to be brought? And does Lucy Letby's legal side have that new evidence?
I think every time there's been a major sort of controversial case which has been overturned, what's happened is that rule on new evidence has been relaxed somewhat, because the judges, the Lord Chief Justice and so on, in making decisions have said, actually, justice demands that we relax that rule. The reason the rule is there, as I understand it, bear in mind I'm a scientist, I'm not a lawyer by training. The reason that rule is there, as I understand it, is to prevent the defence lawyers gaming the system, trying one set of evidence, that doesn't work, let's try another set of evidence and game the system. That's what it's there for. I don't think anybody in their right mind thinks that Letby's lawyers are gaming the system. They're different lawyers now anyway, they're gaming the system. The simple thing was, this thing lasted 10 months. It took me 3 months to read through it all, literally 3 months before I could make a decision in my own mind as to whether this...
Why is that significant? It's not the first trial that's taken a long time, is it? It might be the first of its nature.
Well, because it's one thing to say, if let's say we're a different sort of killing. Let's say it's a shooting, right? And the amount of evidence there is the witness of somebody shooting the person, who pulled the trigger, the forensic evidence, and so on. And the evidence is straightforward. In this case, there is no straightforward evidence. There's no witness of any action at all. Nobody has seen Letby do anything wrong. And we rehearsed this again this weekend with a wrong assertion from the Panorama programme that there had been a very large number of babies put at risk in a previous employment, when she was completely under supervision, close supervision for every turn. Those sorts of things. Nobody's ever seen her do anything wrong. So there's no hard evidence of that sort. It's all interpretation. The entire thing is
data and rota and that kind of thing.
It's datas, rotas, and so on. And in each case, what has happened, I mean, let me give you one example where the evidence was not allowed. There was a professor of statistics at Warwick University who was employed by Cheshire Police, right, to interpret the statistics. She said, no, you've interpreted it wrong, you're doing this wrong. So they sacked her, right? Now, her statistics is more reliable than that of the statisticians they've used because she's more eminent. And so is that new information? It's new interpretation. It's accurate interpretation when the first interpretation was just plumb wrong. Any leading statistician you bring to look at this says, no, the court has interpreted this wrong. Now, you tell me, is that new information or is that new evidence or not? And that's the problem with all of this. A lot of this, whether the information is new or not, is a matter of judgment because it's a matter of which expert you put in front of the court. So, for example, take the Shelagh one. You talked about those eminent experts. They were brought together by a man called Professor Shelagh, a Canadian professor who was the expert in air embolisms, air being injected into the veins. This was supposedly the way that Letby had killed these babies. This was what Dowie Evans claimed. He based that on a paper written by Shelagh, right? Shelagh then comes back and appears in front of the appeal court and says, this is wrong. This is just interpreted completely wrong. And the court say, well, that's not new evidence. Well, no, it's the truth. You know, what you had before was not the truth.
Can I ask you as well?
Most ordinary members of the public would have much less trouble dealing with this, in many ways, in my view, than some very senior judges who are operating to rules that are built up over the years for understandable reasons, but don't always deliver justice.
Well, this brings me nicely on to the question I was going to ask, actually, what you just said there, because I noticed both when I interview him, and when I heard Tom Swarbrick interviewing him this morning, the current legal representative for Lucy Letby is diplomatically and politely unwilling to denigrate fellow lawyers. He's focusing on what he is doing in the here and now, and he's not commenting on how the trial was conducted or more specifically, how Lucy Letby was defended. Do you feel freer than them to say whether you think she was properly represented?
Well, for a start, he's under instruction from Lucy Letby herself. She I think has chosen not to criticise her own lawyers. That's right. Okay. That's her sort of ethical choice. I'm not constrained by that at all, bluntly. Now, I will not go into criticising a lawyer if I don't know the details. And some of the judgments he's made, I wouldn't have made the same judgments, but I don't know why he made them. You know, why he didn't put a particular medical expert in the witness box and so on. I'm not in a position to know his answer, but no, I'm not constrained. So if that's your question, no, I'm not constrained about criticising the previous lawyers. I don't think. I think my view is that the case could have been run differently. It wasn't. There's no great virtue in going back over it again now, frankly.
What's your sense of how far down the line you and others who support Lucy Letby's case being properly looked at again, how far down the line towards that do you think you are? Because historic cases, think of the Birmingham 6, the Guildford 4 and others, the Malkinson case more recently, I mean, they take forever, don't they? They take such a long time.
Yeah. Well, I mean, I tend to say, when people bring me miscarriage of justice cases, my opening warning is this typically takes 10 years at least. That's the norm, and that's one of the things that Letby and Malkinson and others, and the postmasters for that matter, and tainted blood. Go on and on. Our legal system is mind-bogglingly slow at these things, and frankly, it's driven by process, not by justice. This is why I always fall back on what's the just thing to do, what will deliver justice, and what all these cases are highlighting is that our system is badly designed. Our appeal system is badly designed. We have a law commission inquiry going on right now. That's going to take 18 months to look at whether the rules we use, like the ones about new evidence you just referred to earlier, are appropriate or not, whether they deliver the right outcome. There was another law commission study, I think in 2013, I might have got the year wrong, which criticised pretty harshly the way we used expert evidence, something which has been very, very topical in this particular case. And again, we've not done anything about that either. I mean, there's quite a lot of problems, both in our judicial system and in the way we set about fixing errors in the medical system, in the health system, which need to be fixed. Not just for the interests of Letby, but for all of the babies whose lives will be at risk in future, all of the people who are badly treated by the health service. Those things need to be sorted out. And this case is a very sort of high-profile case. But what I can guarantee you is that out of it will come at least three different things: a review of the way we handle evidence, a review of the way we handle appeals, and a review of the way we handle failures in our hospitals. All of those are incredibly important to get right, and that's one of the reasons I picked this up.
OK, thank you for speaking to us today, David Davis, former Conservative Party chair, former Shadow Home Secretary. Just to reiterate that Lucy Letby was convicted of murdering a number of newborn babies at the hospital where she worked, the Countess of Chester Hospital. She was convicted of using a variety of methods to attack a total of 13 babies on the neonatal ward at the hospital between 2015 and 2016. 7 babies died as a result, and she was found guilty of their murder.